Good afternoon, all, especially the chief guest of the day, my beloved Suhrit Sardi, my co-host Hemalatha, and all the judges, senior advocates, and my beloved youngsters. Today, Lex Webinar Series enters its 60th episode. The pathway we have so far crossed was not smooth. We had our own difficulties in engaging resource persons from various parts of the field and various kinds of the field. And we are proud to say that we have made a mark in the webinar world for the simple reason that we never compromised on the quality of resource person and the topics. And thanks to friends like Suhrit Parsarali and judges of the Madras High Court, with whose help we are able to hook to various resource persons around the country and across the country, like Gautam Bhatia and now Chintan. May I now request Mr. Suhrit to have a word about Mr. Chintan to the audience. Suhrit, please.
Sure. Thank you, Mr. Srinivas Raghavan, and good afternoon, everybody. It gives me great pleasure to welcome Chintan Chandrachud to this webinar. Chintan is a lawyer based in London. He holds postgraduate law degrees from both Oxford and Yale, and he also holds a PhD from the University of Cambridge. Chintan is the author of two books, Balanced Constitutionalism, Courts and Legislatures in India and the United Kingdom, which was his first book, in which he compares the British experience of judicial review under the Human Rights Act and the model of judicial review followed by the higher judiciary in India under our constitution. In this book, he shows us how the British model allows for greater dialogue between different wings of government, in contrast to the Indian system, where courts often have to declare laws or actions either void or valid. In his second book, which was published recently, The Cases That India Forgot, Chintan, through a set of 10 judgments of the Supreme Court, tells us how the court has often been behind the curve when it comes to enforcing fundamental rights. The 10 cases which are discussed here are not cases that we often speak about, but these are cases which, as he shows us in the book, are nonetheless notable. This is because these cases, sort of read together among other things, shows us how the court has often remained silent and even perhaps contributed to various misadventures by government that have come at the cost of precious fundamental rights. Now, this book, The Cases That India Forgot, is written in an accessible form and it's meant for wide public readership. But really, both of these books are valuable contributions and they deserve to be read widely. Today, Chintan will be speaking to us on the illusion of substantive legitimate expectations in administrative law. Now, the Supreme Court, as we all know, has often told us that this doctrine of legitimate expectation in its substantive sense is a part of our law. But what Chintan will perhaps argue today is that this doctrine is in many ways fictitious, because as a matter of practice, the evolution of the law in this field has been such that it's almost impossible to make a plea of substantive legitimate expectation and succeed before our courts. We're all eager to hear what Chintan has to say, so let me, without further ado, hand things over to him. Thank you very much.
Welcome, Mr. Chintan. You can handle the floor now.
Thank you, Surit, for that kind introduction. Honorable judges, senior advocates, Mr. Raghavan, Ms. Hemalatha, and of course, Surit. Ladies and gentlemen, the subject on which I will be addressing you today is substantive legitimate expectations in administrative law. And the title of this lecture is The Illusion of Substantive Legitimate Expectations in Administrative Law. Over the last 2 decades, the doctrine of substantive legitimate expectations seems to have become a regular feature in the Supreme Court's jurisprudence. Leading commentaries on administrative law extol the court's acceptance of the principle that legitimate expectations can be invoked as a source of both procedural as well as substantive claims. These commentaries rely on consistent statements to this effect by the court, beginning in the 1990s. Writing in 1998, for example, a 3-judge bench of the court observed that the government and its departments, in administering the affairs of the country, are expected to honor their statements of policy or intention and treat the citizens with full personal consideration without any iota of abuse or discretion. The policy statements cannot be disregarded unfairly or applied selectively. It was in this context the court said that the doctrine of legitimate expectations was evolved, which has today become a source of substantive as well as procedural rights. The very next year, the court observed that the doctrine of legitimate expectations in the substantive sense has become an accepted part of our law. And the Supreme Court has made similar remarks in 2007, 2008, 2012, and even last year in 2019. These observations suggest that the doctrine, giving rise to crucial and difficult questions elsewhere, forms part of constitutional orthodoxy in New Delhi. However, an entirely different picture emerges once we move beyond the rhetoric and examine the Supreme Court's legitimate expectations docket more closely. What I will seek to demonstrate is that the substantive legitimate expectations doctrine is fictitious in India, not in the sense that these observations are imaginary, but because the doctrine itself is illusory. The doctrine has evolved in a way that makes it almost impossible for a claim to succeed. Now, courts confront a distinctive set of questions when a litigant makes a claim based on substantive legitimate expectations. Has a government policy, practice, or promise given rise to a legitimate expectation? And does the expectation deserve protection? Can the expectation be dislodged based on either public interest or other considerations? Finally, and generally most importantly, what are the standards of review to be applied in testing the considerations based on which the expectation has been dislodged? This session, therefore, will be divided into 4 parts. I will begin by establishing the court's resistance to recognizing the emergence of substantive legitimate expectations in the specific instances where they have been claimed. Next, I will consider the broad set of grounds based on which courts will dislodge a legitimate expectation. Thereafter, and third, I will analyze the differential standards of review being applied to these grounds. And finally, I will seek to demonstrate that in the existing doctrinal landscape, claims of substantive legitimate expectations are doomed to fail. Those that have exceeded are either mischaracterized as substantive legitimate expectation claims, or in fact have little to do with such expectations. But before I move on to those arguments, it is briefly worth addressing 2 matters in relation to typology, as well as 2 matters in relation to method. First, in this talk, my focus will be on substantive legitimate expectations in contrast with procedural legitimate expectations. A procedural expectation arises when a particular procedure not otherwise required by law has been promised to the claimant. A substantive expectation, on the other hand, arises when there is an expectation of a favorable decision, so not merely the procedure. Second, my focus will be on the substantive protection of substantive legitimate expectations. Forgive me for that tongue twister. Substantive legitimate expectations can themselves be protected either procedurally, for example, by giving the claimant an opportunity to present their case before the decision-making authority, or substantively, by giving the claimant a substantive right to something. This talk focuses on the latter, although I should clarify that there can sometimes be a very thin line between the two. and it can be difficult to distinguish whether a case involves procedural protection or substantive protection. So those were the 2 points in relation to typology. I also wish to make 2 points which are methodological. The first being that I should clarify that my analysis focuses on decisions of the Supreme Court. I acknowledge that there is a disproportionate emphasis on Supreme Court decisions in several areas of constitutional and administrative law. This emphasis tends to obscure the large body of jurisprudence emerging from the high courts. Although I plead guilty to that charge, at least to some extent in this lecture, I'm hopeful that this lecture provides some impetus for similar research on the development of legitimate expectations in one or more high courts. Second, although my focus will be on Indian Supreme Court cases, I will seek to situate those cases within a comparative context. More particularly, I will consider where those cases fit within the context of the English authorities as well as the Australian authorities. Those jurisdictions are quite interesting to consider because they take diametrically opposite positions on this issue of substantive legitimate expectations. English courts are seen as the proponents, whereas Australian courts have been detractors. And one of the questions I will consider is whether India's Supreme Court has taken a position that is closer to the English courts or to the Australian courts. Let me begin then by considering the court's resistance to recognizing substantive legitimate expectation. The Supreme Court has held that substantive legitimate expectations arise when a representation is made to a person that a benefit of a substantive nature will be granted, or if a person is already enjoying the benefit, will be continued without significant variation. Now, this representation can manifest itself in different ways, through an express policy or a promise made to a claimant or a class of claimants, or established practice giving rise to the expectation that it will continue to be followed. It is the claimant that bears the burden of producing evidence of the policy, practice, or promise. And the doctrine of substantive legitimate expectations has been subsumed within the non-arbitrariness branch of the right to equality under Article 14 of the Constitution. From amongst the earliest cases considering the doctrine, the court has demonstrated a reluctance to recognize the emergence of a substantive legitimate expectation. In the Hindustan Development Corporation case, the question for the court's consideration was whether 3 leading manufacturers of steel train carriages had entered into a price-fixing cartel and manipulated an auction. Now, suspecting cartelization, the relevant ministry in that case deviated from existing policy to offer a larger quantity of the tender to small manufacturers. The large manufacturers contended that they had a legitimate expectation to receive the same treatment as they did for past auctions based on existing government policy. Although the court rejected the manufacturers' claims based on legitimate expectations, it outlined the limits of the doctrine at quite some length. First, the court conceptualizes what I describe as the mere anticipation limit on substantive legitimate expectations, holding that neither a mere anticipation nor, and I quote, a wish, a desire, or a hope, regardless of the earnestness and sincerity of the claimant, nor even a pious hope leading to a moral obligation, could constitute an expectation. Rather, an expectation would only be founded upon the sanction of law or custom, or an established procedure followed in regular and natural sequence. Now, it's worth spending a moment deconstructing these slightly cryptic remarks. If the court was attempting to explain that not every expectation, understood colloquially in the regular sense, constitutes a legitimate expectation, then it was making an innocuous statement. the task of courts around the world grappling with substantive legitimate expectation is to determine whether the practice has in fact acquired the character which warrants recognition as a legitimate expectation. It is possible, however, to read something deeper within the mere anticipation principle, as I describe it. When the court observed that a mere anticipation will not be recognized as a legitimate expectation, that begs the question with what the expression mere anticipation is being contrasted. What is its opposite? The answer in this case, I think, was simple enough, which is a law, a custom, or an established procedure. Read in this way, the mere anticipation rule in the Hindustan Development Corporation case may have offered a word of caution, perhaps, to the unwary litigant that they would not have had a legitimate expectation to every governmental benefit. So every benefit that you're receiving doesn't translate to an expectation or a legitimate expectation. Subsequent judgments, however, have muddied the waters and have interpreted the mere anticipation rule less innocuously. For instance, in a case called Banari Aman Sugar, the question before the court was whether the withdrawal of tax subsidies to sugar mills constituted a denial of substantive legitimate expectations. Citing the mere anticipation rule, the court holds that the legitimacy of an expectation can be inferred only if it is founded upon the sanction of law. Mysteriously, what the court does in this case is to drop the second half of the sentence from the previous case, which was a custom or an established procedure followed in regular and natural sequence, which was the phrase used in Hindustan Development Corporation. Now, Banari Aman Sugars supplies quite a different meaning to the mere anticipation rule. If the court's perception of the universe of claims extends to only two kinds, that is, legal rights on the one hand and anticipations or mere anticipations on the other, then that would, in my argument, deprive the doctrine of substantive legitimate expectations of its utility altogether. If a claimant needs to establish an ex ante legal right in order to succeed in a legitimate expectations claim, then, as most of you are familiar, the claimant would succeed based simply on illegality. There's no need to rely on any administrative law principles beyond that. There's a second important observation that arises in the Hindustan Development Corporation case, which I think is worth highlighting, where the court outlines the dangers of taking the doctrine of substantive legitimate expectations too far, since doing so would risk stifling the room for maneuver in executive decision-making. Whereas procedural legitimate expectations were worth preserving, the court in that case was not quite as enthusiastic about substantive legitimate expectations. And I quote, the court says, "It can therefore be seen that legitimate expectations can at the most be one of the grounds which may give rise to judicial review. But the granting of relief is very much limited," the court says. It would thus appear that there are stronger reasons as to why the legitimate expectation should not be substantively protected than the reasons why it should be protected. If a denial of an expectation in a given case amounts to denial of a right guaranteed or is arbitrary, discriminatory, unfair or biased, or a gross abuse of power, or a violation of the principles of natural justice, the same can be questioned on the well-known grounds attracting Article 14. But a claim based on mere legitimate expectations without anything more cannot ipso facto give right to invoke these principles. These observations shed light on the Supreme Court's reluctance to accept substantive protection of legitimate expectations as an independent basis for judicial review without relying on other grounds of judicial review. Of course, as I've already mentioned, as soon as we start thinking about whether substantive legitimate expectations should only be claimed in conjunction with other grounds, we also need to begin to question whether such expectations play any role at all in the decision-making process. Now, during the course of its decision in this significant case, the court cites a judgment from the High Court of Australia called Attorney General for New South Wales versus Quinn quite extensively. This judgment, interestingly, rejected the doctrine of substantive legitimate expectations. In Quinn, Justice Brennan of the High Court of Australia observed that to strike down a power on the basis of substantive legitimate expectations would set the courts adrift on a featureless sea of pragmatism and unlock the gate which shuts the court out of substantive review on the merits. These observations were almost emphatically endorsed by the Supreme Court in the Hindustan Development Corporation case, where the court said, as cautioned in Quinn, which is the Australian case, the court should restrain themselves and restrict such claims to duly legal limitations. It is a well-meant caution. Otherwise, a resourceful litigant having vested interests in contracts, licenses, etc., can successfully indulge in getting welfare activities thwarted to further his or her own interests. As it turned out, Hindustan Development Corporation was the first amongst a series of legitimate expectation cases to cite Justice Brennan's well-meant caution. The Quinn case is somewhat unusual. It's an unlikely mascot for India, if India is indeed a jurisdiction that scholars believe has eagerly embraced this notion of substantive legitimate expectations. How then do we explain what has transpired in the Supreme Court? Hindustan Development Corporation was decided after the Quinn case in Australia, but well before the England and Wales Court of Appeals judgment, clarifying the role of substantive legitimate expectations in a seminal decision called Coughlin. After Coughlin, so after both the Quinn case, which is one of the leading Australian cases, as well as the Coughlin case, which is the leading English case, were decided, the Supreme Court in India cited both Coughlin and Quinn, which are judgments, I should clarify, that take completely different positions on this question of substantive legitimate expectations in equal measure. So you have both judgments, one from Australia, one from England, taking separate positions, being frequently cited by the court. Now, the frequent citation of these conflicting judgments reflects, I would argue, a broader trend in Indian public law, which is the Supreme Court's adoption of the taxonomy or the language rather than the substance of new doctrine. While the court has enthusiastically appropriated the language of substantive legitimate expectations from Coughlin and other cases, it has been careful to approach these claims with the words of caution offered by the High Court of Australia in Quinn. A similar trend is noticeable in the move from reasonableness review to proportionality review, a matter that I will come to later. Now, perhaps influenced to some extent by the High Court of Australia, as well as some of its own early case law, the Supreme Court later decides to exclude the application of this doctrine from an entire category of cases, that is, cases concerning employment in public services. So in a case called State of Karnataka versus Uma Devi, a 5-judge bench of the Supreme Court was confronted with the question of whether daily wagers, casual employees, or temporary employees whose terms had been extended for prolonged periods of time would have a substantive expectation of regularization with the attendant benefits of regular employment, which I'm sure most of you are familiar with. Now, conscious of the fact that this doctrine could give rise to a new class of what the court calls litigious employment jurisprudence, it not only rejects the claim on the facts, but vetoes substantive legitimate expectations claims in all comparable employment contexts. In the court's view, a person engaged as a temporary employee is well informed of the limited duration of his or her employment. Temporary employees are not appointed in accordance with a formal and rigorous selection process. Even a promise of permanent employment would be inadequate, the court says, since it was a promise that the state is itself not empowered to make. The court was also mindful of the fact that equity for, as it says, a handful of people may deny equity to the teeming millions seeking employment based on fair procedures. Now, there are two ways of reading the Supreme Court's categorical rejection of the doctrine of substantive legitimate expectations in one category of cases, in employment cases. The first would suggest that the court conceived of employment as a special category, a special class of cases to which the general rule should not apply. This reading of the case seems implausible in my view, since most of the concerns punctuating employment cases apply to all substantive legitimate expectations cases. And in fact, this is one of the difficulties with the doctrine. Substantive legitimate expectation claims are usually not victimless. Just as recognizing the right of patients to remain in a care home would affect the quality of care available to other patients, the regularization of employment claimed in the Uma Devi case would have denied employment to those awaiting employment. So this isn't a no-cost scenario, if you like. Thus, it would be tenuous to argue that substantive legitimate expectations claims made specifically in employment cases should be decisively rejected, regardless of the equities and the hardships suffered by the litigants. Therefore, in my view, it's more plausible to read the Uma Devi case as magnifying the court's more general discomfort with the doctrine. The court's categorical rule was probably inspired by the desire to send a message to the high courts, interestingly, some of which at the time were beginning to accept substantive legitimate expectations claims in employment context. The Supreme Court's case law is also peppered with other restrictions, which I won't go into in too much detail, on the invocation of this doctrine. So, for example, claims of substantive legitimate expectations must be specifically pleaded in the original petition and must be supported by clear, sound, and positive factual foundation. In the context of entertainment tax, the court once held that 14 years would not be sufficient to constitute established practice for the purposes of a legitimate expectation. The court has quite candidly admitted that legitimate expectations are a weak ground for judicial review, and consistently with the judgment of the High Court of Australia and Quinn, ordinarily entitled the claimant only to procedural protection of substantive legitimate expectations in the form of an opportunity to be heard or the reasons for a decision. Now, having accepted that the doctrine can be invoked in an appropriate case, the next question that arises for a court is what grounds the state is permitted to raise in order to dislodge an expectation. This question has quite a significant impact on the scope of the doctrine, because a narrow set of grounds for dislodging the expectation would lend the doctrine some normative force, whereas a broad set of grounds would dilute the doctrine, possibly even to the point of obsolescence. Beginning with the early cases, two grounds have been asserted for defeating a substantive legitimate expectation claim. Those are public interest and good faith. At first glance, they may come across as competing grounds. After all, for the government to establish that a policy decision was taken in the public interest would be an entirely different proposition from simply having to establish that the decision, irrespective of its detrimental potential, was simply taken in good faith, which is, of course, a fairly low bar. The development of the case law, however, suggests that these grounds have effectively fused, they've converged, to set up a standard for dislodging substantive legitimate expectations that is remarkably easy to satisfy. A case called Food Corporation of India versus Kamdhenu involved an attempted auction of damaged food grains by the FCI. The FCI was unsatisfied with the bids that it received and began entering into negotiations with each of the bidders individually, eventually choosing to award the tender to someone other than the original highest bidder in the auction. The original highest bidder contended that having offered the highest price in the auction, it had a legitimate expectation that it would be awarded the tender at that price. While recognizing that the expectations of the highest bidder would be given due weight, the court held that whenever the question of an expectation arises, it is to be determined not according to the claimant's perception, but in the larger public interest, wherein other more important considerations may outweigh what would otherwise have been the legitimate expectation of the claimant. Public interest, in the court's opinion, would require cogent reasons for action that were sufficient to dislodge the expectation. The court held that the purpose of the tender was to secure the highest price for the food grains, while giving bidders an equal opportunity to compete. Procuring the highest price for the grains was, in the view of the court, in the public interest, and therefore the inadequacy of the prices offered on the auction was a good ground for negotiating with the bidders individually, especially since all of the bidders were given an equal opportunity to revise their bids. Although the court held that the legitimate expectation would be defeated in this case, in my view, seemed to set up a relatively robust test for public interest. The Supreme Court's answer to the question of who decides what is in the public interest seemed to be the authority, but subject to intrusive review by the courts. Deciding what is in the public interest is far from straightforward. Many factors apart from price could have been taken into account, not least the FCI's commercial standing and its willingness to honor contractual promises. However, subsequent Supreme Court decisions seem to apply a less exacting public interest requirement. One of these involved a claim for the allotment of land in order to relocate 2 petrol stations that would have been rendered commercially unviable by proposed roadworks. The claimant in that case argued, on the basis of representations made by the development authority, that it had a legitimate expectation to the allotment of land for those petrol stations. Rejecting the claim, the court held that legitimate expectations would have no role to play where the state was in the public interest, where the state action was in the public interest, unless the action amounted to an abuse of power. The court was reluctant, and I quote, to usurp the discretion of the public authority and would leave the decision-making authority with the full range of choices available and left to it by the legislature. So this seemed to offer a somewhat different question to the question of who decides what is in the public interest. And we now see the Supreme Court moving further away from Coughlin, that is the English case, and closer to Quinn, that is the Australian case. In many cases, the court has combined the public interest requirement with a good faith argument for dislodging legitimate expectations. So in a case called PTR Exports, textile exporters argued that a change in government policy resulting in a denial of existing export subsidies breached their substantive legitimate expectation. Rejecting the claim, the court held that the executive would be left with its full range of choices when making economic policy. The executive, according to the court, was in a better position to understand the diverse considerations in play, and substantive expectations could not be successfully invoked unless, and I quote, the refusal is mala fide or is an abuse of power, in which event it is for the applicant to plead and prove to the satisfaction of the court that the refusal was vitiated by the above factors. Now, many judgments have adopted the strategy of applying public interest and good faith as disjunctive requirements, with proof of either one or the other defeating a claim for substantive expectations. A good claim can be observed, a good example can be observed from a 2006 case, where the claimants were employees of an organization that had been licensed to distribute electricity, whose work was being transferred to a state electricity board. The employees in that case claimed that an expectation to be employed by the board had arisen, based on the recommendation of a committee that was appointed by the state government. The court rejected the claim for the reason that the state government had specifically considered and rejected the recommendation of the committee, and that the board had never taken on the employees of private licensees in the past. It had never happened before. A legitimate expectation based on established practice was also not established in this case, because the employees had no previous dealings with the electricity board. While discussing the circumstances in which such expectations can be dislodged, the court said that public interest, change in policy, conduct of the expectant, or, and this is important, any other valid or bona fide reason given by the decision maker may be sufficient to negate the legitimate expectation. So this judgment sets a new low watermark for dislodging substantive legitimate expectations, not only suggesting that public interest and good faith are disjunctive requirements, but that any other valid reason offered by the decision maker would suffice. Putatively, this means that decisions taken even in bad faith but in the public interest, or good faith decisions that are either neutral as to the public interest, or perhaps even detrimental to the public interest, would dislodge substantive legitimate expectations. Taken individually, public interest and good faith, as the court has interpreted them, are relatively easy to establish. Taken together as disjunctive grounds, state authorities would find it, in my view, difficult not to satisfy one of them. You'd actually have to work hard to lose in such a case. Once a state authority has put forward a ground for dislodging an expectation, the next and often decisive question becomes what standards of review the court should apply in determining whether the authority has successfully established its claim. The leading case on this question is a decision by the name of Punjab Communications versus Union of India. And this case stemmed from a government tender notification for a project aimed at establishing digital wireless telecom facilities in an identified set of villages. The original notification was abandoned in favor of a new notification for setting up these facilities across the country more broadly, instead of targeting the identified set of villages. The claimant argued that it had a substantive expectation for the original tender notification to be processed. The Supreme Court accepted the government's public interest considerations for changing the policy, which recognized the fact that other regions were in greater need of telecom facilities than the set of villages that were originally identified. Now, this is where accidents of history can be quite interesting, because this case was decided just over 2 months before the famous English Coughlin case, which I referred to earlier, changed the landscape of substantive legitimate expectations in the UK. So until then, the situation in the UK was fairly uncertain. And the court in the Punjab Communications case cites the leading authority then in the UK, which is a case called Hargreaves, as the leading authority from the Commonwealth on questions that arise in relation to substantive expectations. Now, there are two different ways of interpreting the Hargreaves case, which is the precursor to Coughlin. The first places the judgment in ideological opposition to the doctrine of substantive legitimate expectation. And the second is that while no substantive expectation was held to exist on the facts of the case in Hargreaves, if it had arisen, a change of policy based on public interest would have been subjected to Wednesbury unreasonableness review and not proportionality review. The Supreme Court adopted the second reading of the Hargreaves case, arguing that the doctrine of substantive expectations was well recognized, but that public interest seeking to dislodge such expectations would be tested for irrationality or perversity according to Wednesbury principle. The court in that case specifically considered and rejected the idea of applying proportionality review in such cases. Now, although a sizable body of domestic jurisprudence on substantive legitimate expectations had already developed by then, the court's judgment relied heavily on the English court's inclination towards applying Wednesbury Review in Hargreaves and another case called Unilever. As we shall see, Punjab communications was closely followed in subsequent judgments, despite contrasting developments in the UK. So this is where the positions in England and India begin to diverge. One might well speculate about what the situation would have been had Punjab communications been decided shortly after Coughlin, or of course the other way around, if Coughlin was decided before Punjab communications, in which the court was critical of applying unreasonableness review in substantive legitimate expectations cases. Now, it's fairly well established that there are multiple forms of unreasonableness review, or that such review can be undertaken with different levels of intensity. So Wednesbury review is not a monolith. It's really more of a spectrum. The Supreme Court has on some occasions applied more anxious forms of scrutiny than traditional Wednesbury unreasonableness. In Punjab communications, however, the court signaled that a highly deferential standard of unreasonableness would apply in substantive legitimate expectation cases. It observed that interference with the decision of a state authority would only be justified if the court is satisfied that it was irrational or perverse, which is quite a high or a low threshold, depending on how you look at it. The Punjab communications dictum has been dutifully followed in subsequent cases. In one of them, called International Trading Company, operators of foreign fishing vessels challenged the government's refusal to renew their licenses. The court engaged in a detailed analysis of the standards of review applied to public interest considerations in legitimate expectations cases. Citing the Punjab communications case, the court held that a light touch unreasonableness standard would be deployed. This would, in the court's opinion, be a difficult onus for an applicant to discharge, and it would mean that something overwhelming in the court's view was required in order for the court to intervene. This description, in my opinion, calls to mind the quixotic kind of examples that are often associated with unreasonableness review or have been traditionally, such as the teacher who is dismissed for the color of her hair, or the employee who is dismissed because, for example, his name begins with C. The court offers two rationales for its decision to apply pure Wednesbury unreasonableness in legitimate expectations cases. First, the executive had to be offered maximum room for maneuver, maximum headroom in devising its policy. The court was conscious of the fact that substantive expectations cases in which a stricter level of review is applied have the potential of effectively closing off all but one of the options available to the government. Second, the court was not institutionally competent in its own view at formulating policy and should therefore leave the task to the executive. So therefore, the international trading case conceives of the public interest in an absolute rather than in a marginal sense, with the court holding that a restriction would not be unreasonable merely because it operated harshly in a given case, especially when the interests of the country or the economy were involved. This method of framing the public interest test makes it almost impossible to defeat any asserted public interest. It is hard to imagine, for instance, the court accepting the claim of a private licensee in the face of considerations of national security, economic prosperity, social welfare, and the like. When state authorities assert a public interest, the Supreme Court quite frequently accepts the assertion at face value without explicitly engaging in any review whatsoever, not even review based on the Wednesbury standard. For example, in one case, a company claimed substantive enforcement of its expectation to add 3 extra floors to its building based on representations that had been made to the government. Echoing the conception of public interest as an absolute notion, the court accepts the government's argument that when it came to permission for the construction of buildings, public interest and convenience would trump private interest. So in other words, no standard of review at all. Now, what of proportionality review? I'm sure that's a question that's arisen in many of your minds. Now, although proportionality review is dominating the dockets in other areas of the law, it has not yet, at least I haven't yet found, that it has had traction in the Supreme Court's case law on legitimate expectations in the substantive sense. In fact, as I noted earlier, proportionality review was specifically rejected earlier by the Supreme Court. However, there have been some cases in which the court has foreshadowed a possible move towards proportionality review in substantive expectation cases. So in one case, for example, the court recognized that although the traditional approach was to apply Wednesbury review, the European Court of Human Rights had prompted British courts to move towards the doctrine of balancing, which I should say is a popular but misleading synonym for proportionality review in cases under the UK Human Rights Act. In another case, candidates who had been selected for the civil services and were not eventually appointed claimed a substantive legitimate expectation to be appointed to the services. Highlighting that the Supreme Court has applied proportionality review in other contexts, the court held that this case was not apposite for any form of review to be deployed, since the candidates had failed to establish the factual basis for expectations in the first place. Now, proponents of the doctrine of substantive legitimate expectations might conceive of these as encouraging signs. However, in my view, we need to be cautious about making any such inferences. Shifting from Wednesbury review to proportionality review in such cases, as some Supreme Court decisions have predicted, is unlikely to transform the fiction or the illusion of substantive expectations into fact. The key question for me is not whether proportionality review is applied, but how it is applied. The risk being that it will be deployed in a light touch, almost deferential way. This discussion also gives us occasion to think more deeply about the trajectory of the doctrine of substantive legitimate expectations in India. Why is it that the court has embraced the language of the doctrine without its substance? There are, or at least so far I've been able to come up with two possible explanations. The first is that while the Supreme Court is conscious of establishing itself as a progressive player in the global marketplace of rights adjudication, it is genuinely skeptical about the idea of protecting substantive legitimate expectations. I mean, this is by no means an uncontroversial doctrine. It is hardly self-evident that protecting such expectations forms an essential ingredient of promoting the rule of law. Further, as the court has itself noted on many occasions, recognizing such expectations can have involved rather major collateral costs. And it was this kind of rationale that prompted the court in one case to entirely exclude its application to employment. The more benign explanation is that having been trained in the British common law tradition, which was antithetical to the review of executive policy or practice on the merits, judges are still influenced by some of the pre-Coughlin cases. Coughlin was decided in 2001, which declined to enforce legitimate expectations in substance as opposed to procedurally. This explanation tends to fit well with the court's frequent citation of the Australian case, Quinn, which, probably aside from another Australian case called Lamb, is often looked upon as diametrically opposed to Coughlin or its bête noire in the world of legitimate expectations. There is, in my view, some truth to both explanations, as is often the case. Although one would imagine that the first explanation would retain a more long-term influence than the second. Under the second explanation, the doctrine might change with the arrival of a new generation of judges who may be more receptive to recent English cases such as Coughlin, as well as other cases such as BB and Nadarajan. Thus far, I have argued that the proverbial rules of the game have been designed and developed in a way that makes it extremely difficult for substantive legitimate expectations claims to succeed in practice. My analysis, however, would remain incomplete without examining whether these rules have actually closed the door to such claims in practice. If such claims are routinely, or for that matter, even occasionally, successful, it would be somewhat of an overstatement for me to describe the doctrine as illusory. Amongst over 30 cases in which substantive expectations were discussed in any detail during a period of about 2 decades that I examined, the court did not substantively enforce a legitimate expectation in a single case. This conclusion is uncontestable in my view in most of the cases, where the court rejected the claim outright. Other cases are, on closer examination, not substantive legitimate expectations claims at all, although they look as though they are when you examine them from the outside. So all of these cases suggest that the common law has produced exactly the same effect that we might have predicted. In other words, the role of substantive legitimate expectations has effectively been marginalized into irrelevance. Even in cases where the court has drawn upon substantive legitimate expectations, it has done so only as a means of subsidiary support for claims based on surer grounds, which are the grounds you would expect of arbitrariness, fairness, etc. under Article 14. In conclusion, although the Supreme Court has frequently declared that the doctrine is formally part of the law, a closer examination of the court's case law suggests that the doctrine is illusory. The common law rules concerning substantive expectations have both emerged and evolved in a way that makes it increasingly difficult for such claims to succeed. From the very beginning, the court has been loath to recognize the emergence of a jurisdiction to enforce the legitimate expectation of a substantive right or interest. The doctrine has been categorically rejected, as I've said, in a wide category of cases, that is public employment cases. Substantive expectations can be dislodged by establishing public interest or good faith requirements that have in practice been fairly easy to satisfy. The grounds for such expectations are tested on Wednesbury unreasonableness standards, although a formal shift to proportionality is unlikely in my view to dramatically alter the landscape. The numbers confirm what the doctrine insinuates, which is that it is remarkably difficult to find any cases in which substantive expectations have been successfully deployed and vindicated in the Supreme Court. So let me conclude with the question with which I began. Has the court adopted a position that is closer to the English courts, in other words, accepting the doctrine, or the Australian courts, which is the opposite, rejecting the doctrine? My short answer is that the court holds itself out as being more English than Australian, but it is in fact far more Australian than it is English. Thank you.
Thank you, Mr. Chintan. I would rather say that one of the well-narrated session of our webinar, a doctrine which is very much, what I say, uncommon for the past 2 decades, as you said rightly. Very few cases we have seen it is independently applied by the courts. So your attempt is worth, and we appreciate your time and energy. And I have a personal question to you, Mr. Chintan. You have been following the concept or doctrine for the past 2 decades, as you said. Do you think that the predictive expanse of this doctrine in the Indian judicial context would be in favor of Quinn or in favor of Koffler?
It's difficult to predict where the doctrine might go, but at least the indications from where the doctrine has been over an extended period of time over the last 2 decades, as well as where it's been more recently. So for example, I've seen a case involving the doctrine just in October or November last year in the Supreme Court, would suggest that the Indian courts are moving closer to the Australian position, which is interesting. I mean, this is this is one of those doctrines which is very difficult to situate in the world of both public law and private law. And one of the reasons for it is, you might almost say that it lies at the confluence of public and private law. It sounds very similar to the doctrine of estoppel or promissory estoppel, which you cite in private law. However, the English courts have gradually moved away from that, because more recently they've clarified that you don't require detrimental reliance in order to demonstrate a legitimate expectation, whereas you do require that, as you're aware, in order to make a successful claim of estoppel. So there are many reasons, I think, which tend to make some of the courts, particularly the Australian court explicitly, as well as the Indian Supreme Court implicitly, uncomfortable with the doctrine. I've pointed one of them out, which is, where the doctrine is situated in the legal landscape. Another issue, I think, another reason for which the doctrine may make some courts uncomfortable is because it gives rise to one of those very familiar, vexing questions for the courts. In other words, to what extent is it within the domain of the courts to interfere with policy? Right? The distinction between appeal and review, the distinction between simply examining prima facie a decision taken by the government, whereas substituting the decision maker and making the decision oneself. I think the doctrine of legitimate expectations gives rise to precisely some of those questions, which perhaps may be one of the other reasons for which the courts have been reluctant to invoke it wholeheartedly.
Okay. I think a good explanation has come to my question. May I now request Mr. R. Karnanaj advocate to post the question straight to you.
Sir. So it's a very excellent session, sir. Thank you very much for spending your time today, sir. I'm asking the question in terms of legitimate expectation in the Umadevi case, whereas the Supreme Court said no person shall be regularized whenever they appoint through backdoor entry. Now, many cases I can see the state authorities are appointing the person for avoiding other benefits to the workers. They are keep on 2 decades, 3 decades. They keep on asking the worker to serve to state, but they refuse to regularize the persons. Can you distinguish with the Umadevi case and the legitimate expectation in this context, sir?
Thank you for that question. You're quite right, and I think the point you made is one of the concerns that the Supreme Court raises in the Umadevi case. I mean, one of the issues that the court has in the Umadevi case, and the reason for which it decides that we are now going to stop all of the high courts from regularizing employment in such cases, is the risk, as you describe it, of backdoor entry. In other words, regular employment processes are not being followed, the rule book is being ignored, shortcuts are being taken, and so on. And I think the interesting question, at least so far as I've seen, all of the cases in which substantive legitimate expectations claims have arisen in employment context in the Supreme Court have, at least as far as I'm aware, been unsuccessful. The position may be different in high courts, and I suspect, in fact, has been different in high courts, at least up to Umadevi, which was part of the impetus behind Umadevi. I think the linked and quite interesting question is there a good rationale to distinguish between an Umadevi applying, in other words, cordoning off the doctrine from employment cases versus all other cases? Because you might equally envision the backdoor entry, quote unquote, backdoor entry logic applying to any other case. In other words, for instance, if this case quite often arises in medical contexts, which is of course opposite for the times that we currently live in. But in a medical context, it often arises where an individual, say, for example, is not entitled under the law as it's prescribed to a certain quality or standard of care, or to be put up in a care home. but the government informally, quote unquote, backdoor entry, promises to provide a higher level of care than what they're entitled to under the law. Now, is that any better or worse than the employment context in Umadevi? That's the quite difficult question. And in my view, it's no better or no worse. In my view, the court's concern with applying this doctrine in employment cases really can be extrapolated across the board.
Thank you, sir.
Chintan, according to you, it is an illusion as an independent ground of attack, or even as a concept as such, or a doctrine as such? Like what is called the concept of doctrine of manifest arbitrariness, being taken a place of a sole ground of challenging something. Could it be like that, or you will say it is a total illusion?
Yeah, that's an interesting question. My argument is that it could be an illusion as an independent ground. Although that might well be linked with the development of the constitutional law grounds upon which you can challenge a decision of the executive or an administrative authority. Right? Because part of the reason, I think, for which many of these, what will otherwise be independent common law administrative grounds, in other words, your traditional grounds of illegality, irrationality, procedural impropriety, and legitimate expectations, have disappeared into the background, is that they've almost been subsumed and swallowed by Article 14. Now, I think it's probably a question for another day, whether that is or is not a good thing. I think there are many reasons to believe that that may not always be a good thing. But I think it's a fact that Article 14 has virtually, essentially swallowed all of those other grounds. Absolutely.
It's fine. It's a good answer, Mr. Chintan. I may now request Hemalatha to offer her concluding remarks.
Mr. Chintan, today's session was engrossing and stupendous to say the least. Thanks to Chintan, who was at his all persuasive best, which is but natural and unassuming given the stature that he holds today in the legal landscape of this country. We also owe our immense gratitude to you, Chintan, for accepting to address us today, in spite of your grueling schedule, and not to mention the time lag, considering the fact that you are addressing us from London. Thank you once again, Chintan. Thanks a lot.
Thank you so much.
Thank you, Chintan. I should thank Suhrit for creating a nice opportunity to be toying with you. And with that warm note, we bid adieu. I'm hoping to join with you in another session, which is another tough matter. I'm saying and logging out. Bye-bye to you.
Absolutely. Thanks so much. It was lovely to meet all of you.
Thank you. Thanks a lot.
Thank you.
Yeah.